All right, we seem to be stabilizing here, so we can go ahead and get started. So welcome to this webinar by the Center for Advancing Family Caregiver Financial Support and Workplace Security. We are so pleased to be joined today by Liz Morris from the Work-Life Law Center, um, and many of you who are joining us to learn more about how to better support family caregivers in the workplace. And so let's go ahead to the next slide here. I want to acknowledge the support of our funder, the Administration for Community Living at the U.S. Department of Health and Human Services. I do want to acknowledge that the content of this presentation are those of the presenter and do not necessarily represent the official views nor are an endorsement from ACL, HHS, or the U.S. government, but we sure as heck are thrilled to have Liz here. Liz Morris is the co-director of Work-Life Law, which is a national advocacy and research organization that advances gender and racial equality by strengthening legal rights for family caregivers. Their work seeks to ensure that all people have the freedom to build and maintain economic security through employment and educational opportunities without having to sacrifice their health for their loved one's care. And so this presentation will be recorded. And I do want to let you know if you are a member of the Family Caregiver Work Group as a part of this center, please know that we're going to be hopping on after this presentation to a second Zoom link to continue our conversation. So with no further ado, take it away, Liz.
Thanks, Kylie. Really appreciate the invitation to be here today, and thank you for that introduction. I'm the co-director of Work-Life Law, as Kylie shared with you all, and we're going to be talking about the family caregivers' workplace rights. Here's our agenda for today. We'll start off talking about time off for caregiving, and by that I mean unpaid and paid leave. Then we're going to talk about supporting. Okay, great. We have a free legal helpline where lawyers are available to have confidential conversations with caregivers and with the folks who are supporting caregivers about what their legal rights are. We provide information about legal rights and also tailored, individualized assistance to people who are trying to figure out how to navigate requesting time off or applying for paid leave or standing up for their rights when they believe that something illegal may be happening. So we'll jump into the content now. The goal here is to provide an overview about what people's legal rights are and then give you resources where you can get in touch with us, check out our website for more information. Okay, so let's first start talking about time off. And by time off, I mean paid and unpaid leave. And also, we'll talk about reduced schedules. In the mind of an employer or a human resources professional, if somebody asks for a reduced schedule, that may be sort of the equivalent of asking for time off. So if somebody normally works 8 hours and they need to work only 6 hours for caregiving for the next few months, in an employer's mind, that's the same as time off. Okay, so what are the rights here? I think it's important to think about the difference between unpaid job protection and paid leave. When we're talking about time off, I like to separate these two, job protection or FMLA, from paid leave because they are different rights. And sometimes somebody may have the right for job protection, but not paid leave. Sometimes people may have the right for paid leave, but not job protection. And how you access those rights are different. So it's really helpful to sort of think of those as two separate things. So job protection, that's what you get under the Family and Medical Leave Act, or the FMLA, a law that you've probably heard about before. And the FMLA provides unpaid time off with continued health benefits and the right to return to the same or a very similar job. So that's what we mean when we say job protection. You get time off and your job's going to be waiting there for you when you return. Paid leave, on the other hand, provides partial pay or income replacement while you're working less or not working temporarily. And so that's money in your pocket. Whether your job is waiting for you or not, you're unable to work because you're caregiving, and so you have some form of income replacement. So I said job protection, the source of that right is the Family and Medical Leave Act. Paid leave, the source of that are various state laws. Unfortunately, we do not have a national paid leave program, but many states have paid leave programs that can provide income replacement to people who are off of work because they are caregiving. Job protection is just requested from your employer. You go to your manager, to the HR professional, and say, I need time off of work. Paid leave, on the other hand, typically it's an insurance program. You apply with the state agency that administers the insurance program, or in some states or in some cases, you apply with your employer's insurance carrier. So keeping these two benefits sort of separate in our minds can be helpful. So let's first start by getting a little bit more detail on what it means to have job protection under the Family and Medical Leave Act. So the FMLA provides up to 12 weeks off per year to care for someone who has a serious medical condition. And this 12 weeks can be taken a little bit at a time when it's medically necessary. And that's called intermittent leave. So it doesn't have to be taken in a full 12-week block. If there's medical need, uh, then the leave for caretaking can be taken in, a 2-hour block here and a 3-hour block there, or perhaps a week here and then a week later. Whatever the person that you're caring for's needs are, this 12 weeks can be used flexibly over time. And as I mentioned earlier, excuse me, as I mentioned earlier, a reduced schedule in an employer's mind is the same thing as leave. And so that means that if you are eligible to take leave under the Family and Medical Leave Act, then you might be eligible for a reduced schedule as well. It also means that if you work a reduced schedule, your employer can count the time or the hours that you take off against that full 12 weeks that you have available every year. When you are on FMLA leave, the employer must continue providing the same health insurance benefits. And so that means that if let's say hypothetically your employer pays $500 a month for your health insurance benefits and you contribute $100 a month, the employer has to continue paying in the $500 a month, and you would have to find a way to continue paying the $100 a month to continue those health insurance benefits throughout the entire 12 weeks off. And fundamentally, what this provides, as we discussed, is job protection, which is the right to return to the same or a nearly identical job. And by nearly identical, we're talking about the same pay, the same benefits, the same hours, the same level of privileges and responsibilities. Okay, when we're thinking about the FMLA, it's really important to think about who is covered. Am I covered? Unfortunately, a lot of people, because there are strict eligibility requirements, are not covered. So it's always important to keep in mind. All right, so who's covered? People who are caring for a parent, a spouse, a minor child, or an adult child who's incapable of self-care have rights under the Family and Medical Leave Act, the national law. That's a really narrow definition of family. Uh, Fortunately, some states do define family more broadly and more inclusively to include, for example, siblings, nieces and nephews, grandparents, other common family relationships, as well as, in many cases, chosen family, people to whom you're not related by blood or by law, but you have a family-like relationship. The care recipient, the person that the employee, that you as the caregiver are taking care of, must have a serious medical condition. And I've put that in quotation marks because that's actually a legal term that has a legal definition. Unfortunately, it's a complicated, unnecessarily complicated, in my opinion, but it is a complicated legal definition. It means that the person that you're caring for must have undergone inpatient care, so an overnight stay in a hospital or a recovery center, at least one night, doesn't have to be extended, or they have to have some sort of continuing treatment by a healthcare provider. So that could be they had some period of incapacity for 3 days where they were unable to do their normal activities. And they saw a doctor after that. And then they saw a doctor again a month later, or their doctor prescribed some medication. Like I said, I'm just giving examples. It's a very complicated um, legal definition, but the person has to have a serious medical condition. Things like dementia, stroke, cancer, heart conditions, diabetes, mental health conditions that require ongoing care. Those things are all considered serious medical conditions. But things like the common cough or cold, an upset stomach, those are not considered serious medical conditions that would make somebody eligible to take time off for caregiving. As I mentioned, there are strict employee eligibility requirements. Not everybody is covered by the FMLA. Not all employees are covered by the FMLA. To be covered by the FMLA, an employee must have worked for the employer for at least 12 months at some point in sort of roughly the last 7 years. So the 12 months that you as the employee have to have worked for the employer doesn't have to be like the last 12 months. There could have been breaks in your employment so long as the total adds up to 12 months. Um, you must have worked 1,250 hours during the previous 12 months right before you need to start the leave. And that comes out to about 24 hours a week if you are working every week of the year. The employee, in order to be eligible for FMLA leave, also must work at a location where the employer has 50 or more employees within a 75-mile radius. So these are pretty strict eligibility requirements. The impact is that roughly 2/5 of employees are not covered by this law. However, if you don't qualify, you may still have a right to family or medical leave under a state law. And this is a perfect example of why you might want to call Work Life Laws Free Legal Helpline to get information about whether the laws of your state provide a right to take leave, even though, for example, you work for an employer that has 25 employees instead of 50 employees. Okay, so now we know who is eligible to take leave. We understand um, your family member has to have a serious health condition, and you have to meet those eligibility requirements. But what type of care is actually eligible for leave? The good news is this, unlike the other two categories, is actually fairly inclusive. So. A healthcare provider does have to certify that the care is medically necessary, but it's broad what kind of care can be included. So it can include assistance with basic medical, hygienic, nutritional, or safety needs, transportation, physical care, and psychological comfort. So, for example, going with a family member to a medical appointment or driving them to appointments, providing psychological comfort and reassurance to a patient who's undergoing treatment. These are all the types of care that you might need time off to provide. grocery shopping or cooking for a family member who's recovering from surgery. The FMLA would cover that. Helping a family member to eat or to bathe or to meet other or to undergo other activities of daily living. Providing comfort to a family member who is in hospice and arranging for medical treatment or nursing care. These are all examples of the type of care that if you are covered by the law and your child's spouse or parent has a medical need to receive this kind of care because of their serious health condition, you would have the right to take up to 12 weeks off per year under the Family Medical Leave Act, be returned to your job, and have your health insurance continued. So, just to put a little bit more detail on what these job protections are, reinstatement means, and this is sort of the legal slide. Reinstatement means that you can't be fired. You have to be reinstated to the same or virtually identical position with the same pay and benefits. Also, under the FMLA, you can't be discouraged from taking leave. So that means that even if your boss says, okay, you do have a right to FMLA leave, but if they say it's going to be really difficult, oh, it's going to be such a burden, gosh, oh, is there anything you can do to change, that's discouraging somebody from taking leave because people, don't want to upset their employers. And so things that make it more difficult or interfere with the person, with the employees taking leave, those are illegal under the FMLA as well. And also, you can't be punished for taking leave. That's called retaliation. So, for example, when it comes to your performance evaluation, you can't get negative marks because you took leave. When it comes to your performance metrics, those have to be adjusted based on the leave that you take. So, if let's say you normally have to serve 20 customers per year, if you are out for a quarter of the year, that's not going to be possible, obviously. And those metrics, what the expectations are for what work you have to perform, has to be adjusted according to how much time you took off. You also shouldn't be harassed for taking leave. So, yelled at, ridiculed, and shouldn't have any promotions denied. Like, oh, well, you were off a lot this year. We'll consider you again for promotion when next year rolls around, but you haven't done enough this year. All of that can be a legal retaliation under the FMLA. Okay, so I want to just pause us. We've just talked about job protection. Remember, at the outset, I said there's sort of two separate legal rights when you're thinking about time off. One is job protection, and then the other is pay. I'm going to shift gears now and talk about paid leave. Income replacement when somebody is off of work for caregiving is available in 14 states. I've listed them here. Some of these laws are going to go into effect in January 2026 or May 2026, summer 2026. But it's California, Colorado, Connecticut, DC, Delaware, Maine, Maryland, Massachusetts, Minnesota, New Jersey, New York, Oregon, Rhode Island, and Washington. In all of those states, if you are off of work for caregiving, you are able to apply for income replacement or pay since you will not be earning your normal wages. Now, the programs differ by state. There's a range of the way these programs are structured, what benefits they provide, who's eligible. I'm just going to provide a brief overview here of what kinds of benefits and such are available. The definition of family member varies, but many states do include people who are not legally or biologically related but have a family-like relationship known as chosen family or a designated family member. So compared to the FMLA, most of these paid leave programs are actually broad in what they think of as a family member. The wage replacement levels, what percentage of your wages are replaced, meaning what percentage of your wages are you paid during this time, also ranges from 60 to 100%, depending on what state you're in, and 90% is the most common percentage of wage replacement. the programs are sort of a mix of worker funded and employer funded, or both worker and employer funded. And by funded, I mean like who is paying into the pot of money that is then available when people need it for income replacement. So in some states, it's entirely worker funded. In some states, entirely employer funded. In others, it's a mix. What is the duration of the leave? How many weeks can you receive pay for? It ranges depending on the state from 6 to 12 weeks, and 12 is the most common duration for which somebody may be able to receive paid leave. Typically, the benefit is provided through some sort of state fund, but sometimes it is provided through an employer plan. So you would either apply through the state or with the private employer plan. Okay, so that's paid leave, providing 6 to 12 weeks, typically, most commonly, 12 weeks of income replacement, money in your pocket when you're off of work for caregiving. It's also helpful to know about paid sick days, which can be taken for very brief periods of caregiving. So, not for weeks at a time, but for a few days. Um, and this slide shows all of the states that have a requirement that employers, or most employers, provide paid sick days. Um, Based on the number of hours that employees work for them. And so paid sick days is something that you request from the employer, and they just put the money in your normal paycheck even though you didn't work. And so, in addition to all of the states that are listed here, Alaska, Arizona, California, Colorado, Connecticut, DC, Illinois, Maine, Maryland, Massachusetts, Michigan, Minnesota, Nebraska, Nevada, New Jersey, New Mexico, New York, Oregon, Rhode Island, Vermont, and Washington. In addition to those states, roughly 24 cities or counties, local jurisdictions also require employers to provide paid leave. So, this is another great example of, if you're wondering what laws apply to me, you should call Work Life Laws Free Legal Helpline. And I'm going to give you the information for how to get in touch with us at the end. Okay, going to take a deep breath. That sort of concludes our discussion about time off. And now we're going to talk about discrimination protections. What is discrimination? What do I even mean by that? And what are people's rights and how do they access them? So first, let's just talk about what is caregiver discrimination. Caregiver discrimination is negative employment actions that are taken because of the fact that someone is a caregiver. So it could be termination, meaning firing somebody because they're a caregiver, reduced pay, changing their schedule, or other negative employment decisions because the person is a caregiver. Harassment, so yelling at somebody, ridiculing them, treating a caregiver worse than their coworkers when they need changes or freedoms, such as arriving late, taking time off, scheduling changes to meet their family responsibilities. If you give those freedoms to other people, but then you deny it for the caregiver because they are a caregiver, that could be discrimination. So here are some examples that we see of what caregiver discrimination looks like in the real world. And these are the types of things that we talk to people about on our free legal helpline. Denial of a promotion or other opportunities because the employee supervisor thinks that they're too distracted by caregiving. Termination or poor performance evaluations after taking time off. Being singled out for abnormal scrutiny of work. So the supervisor, when they learn that the person is a caregiver, all of a sudden is like checking everything and pointing out every little error, sort of looking for mistakes in a way that they're not doing with other people and that they weren't doing before, even with that caregiver, before their caregiving was known. Harsh criticism, yelling, making offensive comments about the person or the person that they're caring for. Given undesirable, giving, I think is what that's supposed to say, undesirable assignments, or a heavy workload, or no work at all, taking somebody off of the schedule because they're a caregiver. changing the employee to a new schedule that makes caregiving hard with the goal of making it difficult for them to care for their loved one. These are the types of things that we see that come up that are discriminatory. Okay. So I've given you a description of what caregiver discrimination looks like, but is it actually illegal? There is a patchwork of legal protections. It's important to know there's no national law that protects workers from discrimination or harassment because they care for a family member. So we don't have a federal law, but we do have various other federal laws, state laws, and local laws that can be used to protect caregivers from discrimination. What laws apply, whether they apply, depends on the employee's situation, it depends on the employer size. And sometimes more than one law will provide protection for a caregiver if they're being discriminated against, and sometimes no law will provide protection. We do have, and so what I'm going to do now is sort of give a crash course in the different types of laws that can protect caregivers from discrimination. It's not perfect, it's an incomplete patchwork, but I think it's helpful to understand what kinds of protections are out there. Just to sort of get a sense of, okay, something illegal may be happening and I may have rights. Okay, so we have state and local caregiver discrimination laws. And these are laws that actually prohibit discrimination that's based on family responsibilities or caregiver status. So I said we don't have a federal law, but we do in a number of states and local jurisdictions have a law that explicitly says you cannot discriminate against caregivers. And in fact, 1/3 of the American workforce is covered by a law that prohibits some form of caregiver discrimination. However, the definition of who is a caregiver differs from state to state, and most often it covers only employees caring for children. So that 1/3 number would be much lower if we were talking about people who are caring for somebody who's not a child. Here are, I'm going to share now, it's a short list, the states that actually have this type of law in place saying you cannot discriminate against caregivers. Alaska, that's one of the oldest laws, if not probably the oldest, and it prohibits discrimination against people because they're caring for their child. So if you discriminate against somebody because they're a parent, because they're caring for a child, that is illegal in Alaska. In Delaware, they have prohibition against discriminating against caregivers, and they use the same definition of family that we see in the FMLA. So if you're caring for your parent, your spouse, or your child, and you face discrimination, that would be illegal in Delaware. And when I say it would be illegal, I mean if the discrimination was because of the fact that you were caregiving, then that would be illegal in Delaware. Illinois is our newest law, just went into effect in January 2025, and it has a broad definition of caregiving. So if the employee is caring for their child, their stepchild, a spouse, a domestic partner, a sibling, a parent, a mother-in-law, a father-in-law, a grandchild, a grandparent, or a step-parent, if they're providing that kind of care and they are treated poorly because they are providing that kind of care, that is illegal in Illinois. In Maine, the protections are just for people caring for minor children or adults who can't make or communicate decisions for themselves. Minnesota is similar, minor children or a limited subset of adults. In New York, minor children. In Washington, D.C., anyone who's in a dependent relationship. So this is a short list of states, and most of these are limited to just parents or people who are caring for children. My slide needs to get readjusted here. There are also over 300 local jurisdictions that provide this protection. And by local jurisdictions, I mean um, um, counties or cities that give this right. And again, those mostly cover parents. Okay, there we go. I want to now talk about discrimination based on the employee's association with somebody who has a disability. It's illegal under the Americans with Disabilities Act, the ADA, for an employer to discriminate against an employee based on the fact or because the employee is associated with someone who has a disability. And often people that we're caring for do have disabilities, and often our employer knows that. And so this is another way that unfair, uh, poor treatment of a caregiver might be illegal. Associated with is very broad, and it covers caregiving. It covers all family and chosen family relationships. You don't actually even have to have a family relationship with the person. If you're providing care for them, you are associated with them, and you cannot be discriminated against for providing the care for a person with a disability. The catch is that the employer must know or believe that the care recipient has a disability. So if I say, if I tell my employer that my mother is moving in with me, um, and I'm going to be caring for her, and my mother is moving in with me actually because she has diabetes and she needs my help managing it, but the employer doesn't know that, and then the employer discriminates against me. I can't say you've discriminated against me because of my association with somebody who has a disability, because you didn't know, the employer didn't know that that person had a disability. However, if I say to my manager, my mother's moving in with me because her diabetes is really out of control, and she needs my help to manage it. I'm gonna, be helping her with medication, and so she's moving in with me. And then the employer discriminates against me, says, "Okay, you're not, we're not going to be promoting you this year because you've got your hands full with that." That would be illegal because the employer knows in that case that my mother has diabetes, and that's a disability under the law. Other examples of disabilities are dementia, Alzheimer's, cancer, arthritis, heart disease, again, diabetes, vision and hearing loss, depression, and anxiety. So if the employer knows that the person you're caring for has one of these conditions, and then it discriminates against you because of your caring for that person, that could be illegal. And this law applies nationwide to employers with 15 or more employees. Some states have laws that apply to smaller employers. It's also helpful to know that there is a protection against discrimination for caregivers when the discrimination is based on sex stereotypes. It's illegal under Title VII of the Civil Rights Act to discriminate against someone based on gender-based stereotypes that say how the person should behave because of their sex, or a stereotype that predicts how they will behave because of their gender. So I'm just going to give you two examples that are related to caregiving. So if the employer demotes a male caregiver based on the assumption that the employee shouldn't be using his PTO to care for a sick family member because he's a man, so it's sort of a sex-based stereotype, sort of like, oh gosh, you took time off, shouldn't your wife be doing that? And then, the person is penalized at work. That would be illegal under Title VII. Here's one more example: refusing to promote the most qualified employee because of gender-based bias that says that she's not going to be committed enough to her job as a mother caring for a child with a disability, and then promoting a father, another employee who's a father instead. The discrimination isn't because the person is a caregiver. The discrimination is because the person's a caregiver and they are a certain gender. And it's illegal under the Civil Rights Act to discriminate against someone because of their sex, and that includes sex stereotypes. So helpful to know that, and also just helpful to see that there's really this broad patchwork of protections. And that it's complicated. And so please call our free legal helpline once again. What about accommodations? Often when we think about what caregivers need, it's not just not to be discriminated against. They need accommodations. They need changes to where or when or how the job is done that enable caregiving. So, for example, they may need shift changes. I normally work on Fridays and now I need to shift to Tuesdays so I can take care of my family member. Predictable schedules. I can't plan for caregiving if I don't know when I'm going to have to work until the last minute. Excusing tardiness. remote work, carrying a cell phone so they can hear from their loved one who needs their care during the workday. All of these are examples of the types of changes that people may need on the job to enable their caregiving. What is the difference between discrimination and accommodation? This is something that comes up a lot, and people um, um, sort of trying to figure out the difference can be tricky. So, if other people, other employees can do the thing, like they can change their shifts or they get excused from being late, then treating the caregiver worse may be illegal discrimination. However, if the caregiver is asking for special treatment, I need this change, no one else is getting it, but I need it, that would be an accommodation. So here's an example. If Grace tells her boss that she plans to work from home for a month, as her father has just moved in with her and needs care, her boss says no, even though other employees in similar positions work from home all the time, and Grace even has occasionally worked from home before without having any issues. That might be a discrimination. The boss may be saying no because Grace is asking for this um, remote work because of caregiving, and that might be a legal discrimination. But if the boss said, no, you can't work from home, nobody can work from home, nobody does, you've never done it, it's not happening, that wouldn't be discrimination. When we're thinking about the accommodations that we all know caregivers often need in the workplace, um, there's very few legal rights that somebody has because they're a caregiver to get an accommodation, besides leave, which we've talked about with the FMLA. But one creative solution is thinking about the employee's own health condition. So, caregiving employees who are experiencing depression, anxiety, stress disorders, and similar impairments may have legal rights for their own disability under the ADA. Employers must give accommodations for the employee's own disability unless it would be an undue hardship. And because we know the high rates of mental health conditions associated with caregiving, often on our helpline, somebody calls us and they don't have rights because they're a caregiver, but their, social worker or therapist believes that they need an accommodation for their own mental health. And this can be very useful sort of legal tool to help people get what they need in the in the workplace. Similarly, caregiving employees who are experiencing mental health flare-ups or complications, even if it's stemming from their caregiving, if it's because they have a mental health condition, they as the employee have a mental health condition, they may have a right to take up to 12 weeks of FMLA leave for their own serious health condition. And also, if an employee takes leave for their own mental health condition, then income replacement or paid leave may be available under one of those state law paid leave programs that we already talked about. Okay. So I've now given sort of a crash course. I tried to make it as um, friendly and accessible as possible, but a crash course on the legal rights um, of family caregivers. And you can see that it's an incomplete patchwork. There are other protections that caregivers need. At Work Life Law, we advocate not only to help people to access their existing rights, but also to expand the law, to get new laws passed, to strengthen public policy so that caregivers in the future will have more rights. And so I just want to take 1 minute, one slide to share what other kinds of protections caregivers really need. First of all, reasonable accommodations for caregiving itself. Um, Changes in the workplace that enable the person to not only meet their obligations to their employer, but also to meet their obligations to their loved one, to get their job done while still being able to do their family obligations. Also, people could really benefit from a right to request scheduling changes, which is something that we have in a few states and local jurisdictions, cities and counties. Under these laws, employers must respond in writing with an explanation if they're denying somebody's request to change their schedule. So the employee says, can I change my schedule? If the employer is, for caregiving, and if the employer says no, they have to give them a written explanation for why they said no. And most importantly, they can't retaliate against somebody. They can't punish them for making that request. Also, fair scheduling laws are really valuable to caregivers. These are laws that provide advance notice of schedule, or they require the employer to provide advance notice of somebody's schedule so they can plan. I mean, it's not just helpful to caregivers, it's helpful to everybody so they can plan their lives. So, for example, Oregon has a law like this that requires um, certain employers, very large ones, to give at least 14 days notice of somebody's schedule. And if they change that schedule, then they have to provide extra pay for those schedule changes to the employee as a form of compensation. And of course, we need universal paid leave that applies to everyone with job protection and anti-discrimination protections that are universal, that apply to everybody. Simply, if you are a caregiver, um, caring for your family member, you should not be discriminated against. And that's one of the things that work-life law is really seeking to advance at the state level. You can check out Work Life Law's policy tools if you're a policy person on our website, worklifelaw.org. Okay, now I want to talk about how work-life law can help you if you're a caregiver or if you support caregivers. We have first, let me actually, before I get into the information about how to reach our helpline, I have this slide here about red flags. Here are things that can come up in the workplace. And if you see any of these happening to somebody that you're assisting, to one of your coworkers, to one of your friends, to one of your clients, or if this is happening to you, then these are good reasons to call us. A failure to accommodate when others get accommodations or when other people have certain freedoms, but the caregiver doesn't, that's a red flag. Putting caregivers under more scrutiny than other coworkers, other employees, reducing their hours, giving them worse assignments, making negative or offensive comments, firing them, refusing to grant leave, interfering with their leave, so discouraging them from leave, calling them when they're on leave and telling them to come back, cutting their leave short, not returning someone to the same position that they were in before they went off on leave, or treating them worse in some other way, retaliating against them for taking leave or just after they took their leave. If a caregiver is experiencing any of these things or something just doesn't feel right, it may be, and what doesn't feel right may be related to caregiving, then please contact Work Life Law's free legal helpline. We have free support for caregivers and their helpers. Um, our phone number is here, 415-703-8276. You can call and leave a message and we will call you back. We have helpline counselors on staff who speak English and Spanish, and we work with an excellent organization that can very quickly connect us with interpreters in any other language, including Indigenous languages. So please call us. Also, you can email us at hotline@worklifelaw.org. Whether you are the caregiver or just supporting the caregiver, whether you have a quick question about, what law applies in your state, or you have a very complicated issue where you're facing discrimination and need somebody to talk through what your options are and what you might do next, please call us. We're here to help. We also have online resources. This is a hyperlink, so that's not helpful, but you can go to our website at worklifelaw.org and go to our caregiver resources to get information, know your rights materials, answers to common questions. And then finally, I invite you to invite an expert from Work Life Law to present at your organization. If you found this to be helpful and you know another group who would benefit from hearing the same information, we are available to come and speak with you. And I'm happy to answer any questions. I've got my contact information here. If you want to reach out to Work Life Law, we're info@worklifelaw.org. I put the helpline information here, or feel free to just email me directly, morrisliz@uclawsf.edu. And I'd be happy to take any questions.
Thank you so much, Liz. That was fantastic. I didn't know about that we could contact Work-Life Law to have you come to our organizations. That's a great resource. And I learned a couple things like about the fair scheduling laws. That's really, really interesting.
Wonderful.
Um, yeah, so we have a couple of questions on here, and so I'll get started. We have the first one is referring to paid sick leave. So Holly Chase asks, is that something that is outside of other sick leave that she might already have? For example, is there a separate category for sick leave related to caregiving?
Yeah, that's a great question. I will answer it to the best of my ability, and I also want to say there's always so many little details going on in every unique situation that if you have a specific thing that you're dealing with, you should call our helpline. But I will answer just sort of generally. The paid sick days requirements under state law say that an employer has to provide at least, let's say it's 7 days, at least 7 days. But if the employer is already doing that, they're providing, 10 days, they are not required, the employer is not required to provide an additional 7 days. So if the employer is already voluntarily or was already voluntarily providing sick time or leave for caring for family members, longer leave, unpaid, they do not have to add anything on under the laws. But if they're not providing sort of the bare minimum that the law says they have to provide, then they would have to change their policy to meet the requirements of the law.
Great, great. And then another question from Holly about discrimination. So it sounds like there might be a story here. We won't be nosy though. So she says, does discrimination cover when a manager says your sibling should be helping you and you say you need to choose, or and says to you, you need to choose between your job and caring for your parents, and a follow-up to that, the plot thickens. She says she never wrote down that this had occurred, so there doesn't appear to be a record. It was 2 years ago. Can she still address it with HR?
Yeah, that's a great question. So this is definitely somebody who should call our free legal helpline. But I'll just note some of the things that are standing out here. First of all, um, making like one comment about shouldn't your siblings be helping you, like that wouldn't rise to the level of discrimination. But like constantly like badgering you, yelling at you, making it like really intolerable in your workplace because of that, and that's like one of the things that they keep saying, that could be harassment. Also, if they took some sort of negative action in terms of your job, like they lowered your compensation, they changed your schedule, they didn't give you a promotion, they demoted you, um, then those comments could be evidence of discrimination as well. The other thing I'll note is that we often see this coming up where the employer or the manager sort of has their own idea about who should be providing the care. And and like there's some, again, call our helpline because there's some small exceptions here and there, but generally that's not any of the employer's business. If you are the caregiver and are the family of a family member and you meet the definition of family and all of that, like that's not the employer's business. They don't get to decide. There can be other people who are also caring. So long as your care is necessary, then that's the end of the story. So that's something that we see coming up a lot, where the employer thinks, and often it's based on like gender as well, where the employer thinks that they get to say who should be doing the caregiving, and that is not accurate. But please
Excellent.
call our free legal helpline, and it will depend what law your rights are under, but sometimes even something that happened 2 years ago could still be actionable.
Good to know. All right. So don't hold a grudge, but hold on to situations where you might still be seeking justice.
Yes.
Uh, and Tasha asked, is the hotline available to all states, or are there local state hotlines that she should share with caregivers? So she's in Iowa and she refers people to the Iowa Legal Aid. Should she share other options?
Yeah, that's a great question. Um, we operate, and I should have mentioned this, so thank you for raising it, Tasha. I appreciate that. We operate in all across the United States. In all states, we are very knowledgeable about this unique area of law, caregiving, as well as like pregnancy issues, health issues. And so we have resources that allow us, if we don't already know it, to look up the law of a particular state. So we are able to provide information in all states. In Puerto Rico and DC, you can contact us. I don't know specifically about the legal aid organization, of course, that you are referring people to. But generally, legal aid organization lawyers have so many things that they're dealing with and may not have the same level of expertise on this very sort of complicated and specific issue of employment law. And so I would urge you to have people uh, call us because we can help them regardless of where they're located.
Quick follow to that from Sharon. Hi, Sharon. For clarification, that includes Hawaii as well. That work-life law can you can reach
Yes.
out. Good.
Yes. Yes. Anywhere in the United States, we are able to provide support. Now, we're not providing legal representation. We're not going to take you on as a client anywhere in the United States, but we can give you information about your legal rights. We can talk through possible options that you might want to pursue. We can put you in touch with, if you do end up needing legal representation, we can help put you in touch with lawyers who practice law in your specific state if you are going to file a lawsuit. But often on our helpline, we find that we're able to help people to resolve their issues when they're still employed, to like get what they need without having to resort to that. And that's always our goal. It's important to know that there are legal rights and you could go to court. Like that's important, and it motivates employers to comply with the law, the fact that you can sue them. But our goal is always to help people to get what they need in as frictionless a way as possible. And often just having the involvement of work-life law, because we are lawyers, can be helpful in getting that leave, in getting that accommodation, if there is any basis in the law for having that.
Excellent. And I want to let everyone know if you do have a question, please feel welcome to share it in the Q&A box on Zoom. I wanted to ask a question, Liz, if you don't mind. You mentioned earlier in your presentation about family medical leave that it could be taken um, intermittently if you needed it. Are there scenarios where an employer could refuse to allow you to take it intermittently?
Yes. Okay. So in order to take intermittent leave for caregiving, it has to be medically necessary, and a healthcare provider would have to sign off on it. I mean, a healthcare provider has to sign off on leave whether it's intermittent or not. So, but the healthcare provider could authorize it. This isn't really what we've been talking about here, but I will just mention that if you are taking leave to bond with a new baby, which is something that's also available under the FMLA, then you do not have a right to automatically be able to take that intermittently. That would be something your employer would have to agree to. But if you're taking it to care for a family member and it's medically necessary that, you need to take them to their appointments every Tuesday to get chemo, uh, then then you have a right, and the employer, again, assuming you're covered by the law, but then you have a right and the employer cannot deny that. And if they are, oftentimes this is a great example of the type of thing where we're not going to need to go to court and sue your employer. All we're going to need to do is write an email that explains what the law is and cites it, and then you can take that to your employer, and 9 times out of 10 they will change their actions because they know that that there is legal recourse, but typically it just doesn't even get to that.
Excellent, excellent. Thank you so much for, I think it can be intimidating to speak up to an employer. Lots on the line, your person's income. So thank you for sharing about kind of the different levels of support, getting information, sending an email. It's not automatically, hey, we're going to court, which is a scary step, right?
Absolutely. One of the things that we do for people on the helpline is we actually just review messages that they are going to send to their HR so that their HR doesn't even know that they've reached out to a lawyer. And I think typically people's goal there is to prevent any kind of escalation, that where they write an email that just sort of says, "Hey, I was searching online and I found this." And then we give them the thing that they should cite, the hyperlink to whatever resource. Um, but we're able to help people take into account what risk they're running by pushing back with an employer, because of course there is risk there as well, and we understand that. And it's always up to the person on the helpline whether to even pursue something. Sometimes we talk to somebody and we say, "Your rights are being violated," and they say, "Thank you, I'm not comfortable doing anything about it," and they have the information and they've made that decision.
That makes good sense. Absolutely. And then again, on this, carrying on with this employer discrimination topic, and I'm hoping this doesn't mean that a lot of people are experiencing it, but it's good that we have the information. How far back can an employee request support from an organization like Work Life Law if they were negatively impacted from discrimination and harassment to the point where the employee was pushed into resigning?
Yeah. So it depends what state the person is, what law we're looking at. I have not seen a state law that provides more than 4 years. I think typically it is 2 years, um, but it could be 3 years. So it really depends what state we're talking about. And there, so there is some hope in that sort of longer period going back. Um, I will also say though, because I don't want to deter somebody from calling us just because it was a few years ago. Um, if it was 10 years ago, there's probably nothing you can do. But, just because it was a few years ago, there may be something you can do. But I will say that it is very important to call us as soon as possible, because oftentimes, if you have to file a complaint with the EEOC, the Equal Employment Opportunity Commission, for example, let's say you have one of those sex stereotyping cases, or an associational disability discrimination case, and you only have federal law, you don't have a state law, you may have to file something at the EEOC within 180 days. So we will do everything that we can to figure out creative ways to extend the period of time when somebody has to assert their rights, but often it is a fast turnaround. And so uh, you can just call us and find out. You can at least just get the information. You don't have to take any next steps, but it's always good to call us sooner rather than later because of those kinds of deadlines.
Wonderful. And I have one more question. I know we're pushing up against our time here. Let's say you were an employer
Mhm.
and you are employing a caregiver who maybe you start to see some signs of presenteeism, some changes in their work pattern. Um, what should you know about working with that employee? How do you make sure that you're not acting in a way that's discriminatory, and maybe what resources you should consider?
Yeah. So we do have some resources on our website for employers. Um, and if somebody is like a small employer and is really sincerely trying to do the right thing, we will occasionally give information on our legal helpline to those people in an attempt to help them to comply with the law if they don't have resources to go get, a lawyer. Um, I think if you are a larger employer, what I would do is preempt any of this by getting a training on caregiver discrimination and family responsibilities discrimination from your general counsel or a human resources professional. And I have wonderful consultants who do those kinds of trainings that I could refer you to. So feel free to reach out to me by email and I can give you the names of those. If there's a specific situation going on, though. The things that I would keep in mind are, am I treating this person any differently than I would treat them if the reason that their work, was changing or whatever was because of something other than caregiving? Because if you are, in other words, this person is asking for, to leave early. If they were asking to leave early because they were training for a marathon, would I be having the same reaction, right? Or this person has made a mistake. Am I noticing it because they're a caregiver and other people are making mistakes and I'm not really noticing it? Right, that would be the kind of thing that I would want to pay attention to. And also, like, as a human, I would just want to give somebody grace if, they have a loved one who's facing really significant health challenges. Supporting caregivers boosts loyalty. It ultimately increases employee retention. We all know that turnover is very expensive. If you support somebody, even if you're not required by law, through a major crisis in their life, they will return. There will be a return on that in terms of increased loyalty, productivity for years to come. People remember those kinds of things. And in addition to my opinion, that is backed by a lot of business field research. So yeah, that's what I would say.
Fantastic. I love it. Lead with respect, right?
Yes.
Um, Thank you so much, Liz, for your time. This has been incredibly valuable. And you have Liz's contact information here and the work-life laws information here. Please, 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 as you log out today, be sure to complete the evaluation that will pop up as soon as you click leave on the Zoom screen. We really want your feedback so we can produce products and inform a clearinghouse for family caregivers and employers in the future. And then if you are a member of the caregiver work group, I will be seeing you on our next Zoom to continue the conversation. Thank you again, everybody, and I hope you have a great afternoon.